attending a few weeks ago. My apologies for having to reschedule. But anyway, I'm going to kind of give a little bit of a very tiny what is kind of immigration system, which are some things you should know, and then go through what we call a Know Your Rights presentation that we would typically give to individuals who are immigrants or have immigrant family members. My understanding is that what you guys might be served best by is knowing kind of what to counsel your clients or other people you're interacting with on a regular basis with relation to the immigration system, or what you should know that might be valuable. But I'm happy to take questions at any point. And I think we've booked about 2 hours. I don't think this should take 2 hours, so feel free we'll have time for questions at the end, or approach me, or we can talk at another point too. So she mentioned I typically work with unaccompanied children, but Merck does a lot of other things. We are a statewide nonprofit that has been around for almost 10 years now, part of a larger organization called the Michigan Advocacy Program. But we started off doing things along the lines of equipping and training other attorneys who are working in this field, and then beginning to do our own direct services. So right now we have offices in Grand Rapids, Kalamazoo, and Ann Arbor, and about 20 staff. So just kind of dive right in here. So here in Grand Rapids, just a little background on the immigrant population and refugee population. So they're not up to date necessarily, but the most recent statistics we have are that the foreign-born resident population of Michigan is about 616,000. It's convenient that it's a 616 number. But the total number of non-citizens is 301,000, 6.2% of the population in 2003, up from the 3.8 in 1990. We also have 9.1% of Michiganders who speak a language other than English at home, and I think Kent is, sorry that cut off, I think the second largest county, I think after Wayne, that has non-English speakers is their primary language. Then we have in the Grand Rapids Public School, you have more than 4,000 students with limited English proficiency. So the third largest LEP population in a district in the state. And the estimated number of unauthorized immigrants in Michigan is 120,000. And then 158,000 is a slightly larger number because we do have a population that tends to migrate throughout the country for seasonal work. And West Michigan is a large recipient of that for things like apples, blueberries, celery, cherries, those sort of things that they'll come into for harvest season and then go elsewhere for a different harvest season. And then there's the number of children with one or more foreign-born parents in Michigan is 265,000 plus. So 12.5% of all children, and 14.1% of all children in low-income families have one or more foreign-born parents. It's likely significantly higher in Kent than in the statewide data. And one thing that is particularly important about that, and I don't know that I have a slide about it, so I'll mention it now, is we're currently seeing some regulations being proposed by the government that will significantly affect what families are able to partake in with regards to public benefits. And so currently, families who have children who are citizens, even if the parents would not be eligible for public benefits, they can get public benefits on behalf of their children. There's a regulation that the administration is proposing that will likely make it a problem for parents of citizens to take those benefits, even if their children are eligible. So we expect that the regulations will go through, and that many families whose children otherwise are eligible, because the parents could be prejudiced by any immigration proceeding they have in the future by taking those benefits, they may choose to not take them as a whole family. So that's something that, go ahead.
I might have missed this, but is that federal or state? Is that a federal regulation?
It's a federal regulation, sorry, but it would apply to any benefit.
Okay, so it's federal regulation.
Yeah.
All of that stuff. Okay.
Yeah. And the regulation is relating to immigration. It's called public charge. It's a ground of inadmissibility. So you have to first have a visa or something you can qualify for, and then after that they check to see whether you're admissible. And it's a whole long list of categories that can disqualify you from applying for something you otherwise were able to apply for. And one of them is called public charge, if you're ever expected to be a public charge. And that used to be defined pretty narrowly, but what they're trying to do, what the administration is trying to do, is expand the definition to include any use of public benefits, whether for yourself or your family. So just a note on that population number. So one of the things we like to talk about when it comes to the immigration system is that many of us, especially those of us in the white dominant culture, may not realize the full extent of the immigration system in its nature. And maybe because we ourselves have not had to deal with it, or it may have been easier for some of us or our families than other people. But we believe that the immigration system was a system created to perpetuate white supremacy, and that it still is to this day. And that I bring that forth to you all, and in general to most people we speak to, because I believe it's a disservice to deal with an immigrant and the issues that they're facing without recognizing that they are being burdened by a system that is racist and that is working against them. And so when we try to work within the system, we have to recognize that many of us, it's sometimes hard to see what's happening when it's been happening all around us for all of our lives since it's been going on for generations. And I'll show you a specific example by why we believe that. But this little slide about nice water today, there's a proverb about a fish who's swimming along and another fish passes by and says, nice water today. And the one fish is like, what's water? And this idea that when we're in something, we don't even realize it. And that is, the immigration system has, in some fashion or another, been around for about a century, and it's been shifting and changing, but for many of us, we just don't even realize it if we're not having to deal with kind of maybe the ugliness of it. So we just want to make sure that is there, and not to dishearten everybody to start off on a white supremacy note, but just to recognize that that's the reality of the immigration system. So to show you one of the clearest examples of kind of where we see that the immigration system was not hiding the fact that it was about white dominance or white supremacy. This is early. So first there was a case before this one. This is United States v. Bhagat Singh thing. It went to the United States Supreme Court. But before that, there had been a case that was decided on the Chinese Exclusion Act, where a man who had been born in the United States, his parents were Chinese, they had come over to work on the railroads, and he had applied for U.S. citizenship. And the U.S. Supreme Court ultimately said you can't be a citizen, in part because of the Chinese Exclusion Act, but also in part because you are not white. Or they said the word Caucasian was the word they used in that decision. And the Supreme Court was clear, only people at that time that could be citizens were Caucasians and blacks. And how blacks got included in there, they have their own history of large institutional racism that continues, and they got worked into the citizenship due to the Reconstruction after the Civil War. So, but the big question is, who qualified as white or Caucasian? So then, Bhagat Singh was of Indian descent, but was born and raised in the United States, had a family, had served in the military, owned property, owned a business, and he was wanting to claim U.S. citizenship. And so he went and was denied at the lower levels when you make your applications, and went all the way to the Supreme Court. So his argument was that he was Caucasian because, as the word Caucasian comes from the Caucasus Mountains. And if you trace genealogy, you can find that individuals from India are descendant from the Caucasus Mountains. And so he made that strong biological, genealogical argument to the Supreme Court, and they said, no, we know who is white and you are not white. And so they took away the word Caucasian and they replaced it with white. And they said, you cannot be a citizen. At that point, a lot of the lower offices, because typically it's not the U.S. Supreme Court deciding who's citizens or not. This is big big case law. So usually it's lower offices that make those decisions, and other Indians had gotten citizenship. He had just been denied by a particular officer. So after this decision, all Indians were stripped of their U.S. citizenship, and at that time, without being a citizen, you couldn't own property, you couldn't, so there was a significant loss in addition to not having the rights of citizenship. This has since been rescinded so that, thankfully, on its face, this is not the law anymore. But it is the history out of which we have come in our immigration system. And even though we don't have it as law, it is still the building blocks on which our system was built, unfortunately. So the basic framework of immigration today, of the immigration system, is you can kind of group things into these categories. So the employment-based, we also include student visas in that, is generally reserved for high skills, as defined in the law. We think many jobs that the immigration system does not define as high skills still require extreme levels of skill, but that's just how, usually college education or some sort of high degree or particular, maybe getting an award like a Nobel Prize or something like that, depending on, can be defined as high skill. And permanent visas require that no U.S. worker can do that job, and these are petitioned by the employer. So you don't ask for your own work visa. The employer petitions that for you. So the employer has to say, I have a job, no U.S. worker can fill that job. They have to show that they've posted the job, made attempts, didn't reject a U.S. worker unnecessarily, and then they can petition for that person to come to receive the visa and come and work for them. And those can eventually lead to permanent residency and citizenship, depending on the particular type. There's a whole array of those, but it's very hard to get, given that the level of education that's required and the fact that it has to be after no U.S. worker has obtained it. There are others, the family-based immigration. First, you have to get a visa, and you can get that visa through certain family relationships. The most common is being the spouse, child, or parent of a U.S. citizen. You also can have certain the most distance you can get is being a brother or sister of a U.S. citizen. You can also get a visa by being a spouse or child of a permanent resident. And so one of the things to note is that getting that visa is, first you have a very limited number of relationships. There's a lot of misconceptions about how far out you can reach in that family tree to get a visa. And there have always been a lot of myths around the family-based immigration process. We used to hear a lot about the anchor baby myth, and now we're hearing a lot about chain migration under this administration. And there are things that are very flawed about those ideas, and I'll kind of address those, but also the importance is that, families, one of the values set forth in our systems is that families should be together, but in practice, that doesn't really happen. So because first you have to get this visa, so you can only have one of those limited number of relationships. And so one of the myths about chain migration is that it's very, a lot of people could benefit from it, but it's a very limited scope of people. And then you have to adjust or consular process. So that means you have the visa, you have to go to your consulate and go through, make sure you don't have any grounds of inadmissibility, or just wait. So some of we can talk about it one-on-one if it's ever something you're interested in, but there's actually a visa bulletin that says, other than immediate relatives of U.S. citizens, so other than minor children and spouses of U.S. citizen, everybody else has to wait. There's a category, a visa bulletin that gets published every month that says how long you have to wait. So brothers and sisters of U.S. citizen is the bottom of the categories, and they typically have to wait 14 to 15 years. Just so they'll have their visa, but they have to wait to be able to do that second step, and you can't come in without that second step. And so the idea that people are just really benefiting from this system is not really accurate. And secondarily, you have the fact that there is the bars, and these bars, one of the most important bars is that if you've been in the United States without status for a period of time, depending on how long it was, might determine how long your bar is, but that means that when you leave the United States to consular process, because you have to do that for most people in your home country, when you leave, you trigger a bar. That means you cannot return to the United States most of the time for 10 years. So if we look at the anchor baby myth of, you know, a woman who comes here, has her baby in order to get citizenship through that baby, because the baby gets citizenship at birth. But the baby first has to turn 21 before they can petition for their mother. And then, if the mother has been here undocumented, and she returns to her country to consular process, she then has to wait another 10 years before she can consular process. And then there is the second element of the public charge. They have to show that the person that they're sponsoring, so that U.S. citizen child would have to show that they can support themselves and their mother and whatever other family is in their immediate household at or above the 125% of the poverty line. So this really means that it's not the reality that people are coming to have babies to get citizenship. People are coming and having babies because people move, people have babies as part of the human experience, but it's not this big scheme to benefit from the immigration system, because it truly doesn't allow them to do that. And kind of back to the point about the visa bulletin and having to wait. The visa bulletin is also divided by country. There's some that are general, but other countries, especially Mexico, the Philippines, and China right now, for the family visa bulletin, have extra delays. So it's one of those things where it facially looks neutral because there's a 7% cap on every country. No country can benefit for more than 7% of a particular type of visa. But in practice, this is one of the ways where we see it playing out, that the countries that are hindered by this are countries with people of color. And one other way that our system continues to display its racism. And there are other countries that don't even require visas. So most European countries are actually part of a visa waiver. So to visit, they don't even require a visa. And so that's where you start to see some of that imbalance. If somebody from one of those countries can come and visit without even needing a visa, but other countries have to apply, they'll meet their cap much quicker. And then there's a visa lottery, which the president would like to get rid of, but it currently still exists. It's for low admission countries, so countries that aren't at that 7%, they can apply. You have to have a high school degree and meet certain financial requirements, but then you can it's literally a lottery. They just draw your number and you may end up coming. It's called the diversity visa lottery because the idea is that it's collecting from countries that otherwise aren't high sending countries. And then there's the void. So if you can't fall into, I'm sorry, I missed the humanitarian. With humanitarian immigration, that is refugees and asylees who have the same definition but are processed in separate places. So refugees are processed abroad, asylees are processed at the border or in the United States, seeking protection from harm or persecution in their home country. U and T visas are for victims of crime who have been helpful to U.S. law enforcement. U's are for a large variety of crimes, but they have to be serious, and T is for trafficking victims. VAWA is for our victims of domestic violence who otherwise should qualify for family-based immigration, but their partner, or it could be parent too, is not making that application for them as a tool of violence and control. So they're saying, then they'll always have the threat of, I can call and have you deported if you don't do what I want, or just as a general intimidation tactic. And so this allows the people to petition for themselves when otherwise the abusive partner or person would have had to do that application. And TPS is temporary protected status. So that's for it's designated by the government every year which countries are going to have TPS. It's typically due to large-scale national emergencies, civil war, things that are not particularized to one person, where if it was to one person, they would be able to apply for asylum. But like Haiti after the earthquake got TPS. It's been scaled back significantly by this administration. They're have put dates of expiration on most of the TPSs, which had been continually renewed, but we see Haiti's is going to be expiring in about a year. Honduras, El Salvador had TPS, and those are be expiring. Syria had it, also will be expiring soon. So yeah, so if you don't qualify for any of those, then there's the void. There's just nothing else out there for people. And these others are all very limited and difficult to get, even if you might qualify, even if you have a high, are qualified and high skills, you know, do you have that employer who can apply for you?